All right, boys and girls, moms and dads, children of all ages, Todd Vandermine back again for a late breaking edition of Freedom Steel, former NRA contract lobbyist and Illinois gun law guru. We have breaking news in the Illinois gun ban cases. Cue the alert. So here we are. So this afternoon, in the Seventh Circuit Court of Appeals, the court sat there and issued an order in the case of Beavis. So this three-judge panel, headed by frivolous Frank Easterbrook, and then with Justice Diane Wood and Justice Michael Brennan. So on this, it is under the Beavis heading, so Beavis et al. Versus City of Naperville. And they also lumped in Javier Herrera, which is that challenge to Cook, Chicago, and the state. So let's read the order here. Herrera versus Raul is consolidated with Barnett v. Raul through 23-18-28. These appeals will be briefed on the following schedule. Briefs for the governmental parties, whether appellants or appellees, are due June 5th. Briefs for the plaintiffs are due June 19th. Reply briefs, if any, are due by June 26th. Motion to extend these dates or allow late filings by amici will not be entertained. One litigant may file only one brief in all 5 consolidated appeals, and the court encourages multiple litigants on the same side to file joint briefs to the extent possible. So, the state goes first. We go next. The state gets to respond. Easterbrook has given the upper hand to the state, and they get more pages than we did on that issue. The state only gets one brief for all the cases, and that means that Cook County and Chicago and whoever else are lumped into this stuff have to file with the state. They get one brief. We get one brief for all of our side. These consolidated cases with Beavis versus Naperville will be argued the morning of June 29th. Argument is set for 90 minutes, with the governmental litigants sharing 45 minutes and the litigants contesting the laws sharing 45 minutes. The court encourages counsel to agree on an allocation that minimizes the number of different lawyers who will present argument. If counsel are unable to agree, they should notify the court, which will allocate time. In the meantime, the statutes remain in effect. This court already has denied a motion for an injunction pending appeal in Beavis, and as for the Barnett appeals, based on our review of the party submissions, the breadth of the litigation, and the differing conclusions reached by different district judges, we conclude that the stay of the district court order already entered will remain in effect until these appeals have been resolved and the court's mandate has issued. So, what does this mean? One, Easterbrook is, in my opinion, trying to tip the scales and put his thumb on the scales for the state to give them more pages, more opportunity. Now, looking to see whether Cook County, Chicago, who all wants to get into that food fight over there on their side, going to be interesting, or are they just going to let the state argue? We don't know. Naturally, we are now going to have a bit of a discussion on our side because you have the Herrera folks. I'm not impressed by their lawyering. You have National Association for Gun Rights representing Beavis. You have Paul Clement, Aaron Murphy, and NSSF. You have Michelle and Associates on our behalf. Cooper and Kirk have now weighed in on the ISRA SAF complaint. So you have a whole litany of lawyers here. It would have been slightly better had they just simply allowed us all to argue our own cases instead of throwing us all into this jambalaya of what there is. Now, here's some news. Again, here's some more breaking news this afternoon. Let's once again cue the alert. And with that, I was just informed before I sat in front of my computer that the state of Illinois has filed this notice, this order from the Court of Appeals with the Supreme Court. So let's think about this. Judge Easterbrook has got to know Frivolous Frank knows how feckless and frivolous and worthless his opinion in Friedman is. And because of that, they are rushing with all light speed. Remember that letter that Justice Alito and Justice Thomas wrote after the Second Circuit Court of Appeals was denying and staying all the injunctions post New York? Remember that letter that we talked about in my video earlier today? So what you have here is obviously they have seen the writing on the wall. They listened that when the Justices Thomas and Alito wagged their finger at the Second Circuit Court of Appeals and told them, don't dally, you can't be giving unreasoned orders compared to well-reasoned district judges' opinions. And so I think that Easterbrook, he may not be the greatest litigant in the world in my mind, but at least he comprehends when an inferior court is being lectured by the Supreme Court. So what they want to do, they want to shut off. Now, yesterday was the conference. So the state is running to the Supreme Court as fast as their little feet can carry them in order to head off anything that Justice Barrett may have convinced the court to do. We will get orders on Monday. If they took it up and made a decision about what to do in the Naperville case, that will come out early Monday morning. And if they did, the only way I read this is that smell. What is that? That is the smell of fear on behalf of Frivolous Frank and the state of Illinois. That these guys are terrified that the jurisprudence of Friedman and Wilson and all that other bullshit is going to come to a crashing end very, very soon. And can you imagine what it would be like if the court were to issue an order for an injunction against Beavis and the state, against Naperville and the state? What if the court were to wag its finger and say, you're not paying attention to what we wrote in New York? We already remanded 4 cases. That's what I'm hoping for, that they issue a clarifying letter admonishing the lower courts that they don't seem to have grasped the scope of New York and what the court said last June. So here we are, and this means that our cases from the Southern District with a very good injunction and reasoned opinion are now caught up with everything else. The interesting thing is that Veramontes, the case that was filed a couple of years ago, is now, lagging behind everything, even though they are scheduled for full-on orals and their briefing schedule is almost complete. The judge there, when Judge, can't remember if it was Rovner or somebody sat there when she had the big oral, the call-in. I mean, when there were hundreds, 500 plus people calling in to listen to those oral arguments, that she thought they were going to be in the best position case to move forward. That it was the most complete case because of all the briefings and everything. But that's not going to be the case, as we see here. So June 29th, going to be a very, very big day for oral arguments. The good news is this 3-judge panel that issued this order today with Judge Easterbrook may not be the exact panel that hears the oral arguments. What I'm going to cross my fingers and hope for is that Judge Sykes is on there. And don't forget, we still have the opinion in Atkinson pending out there. Atkinson could come down and be the controlling case. If Atkinson comes down and sets how the panels or how the court is supposed to deal with New York in the text, tradition, and history of the Second Amendment, then Atkinson becomes controlling. Just like Friedman was issued before Wilson, therefore Friedman was controlling when Wilson went up, even though frivolous Frank thought feelings somehow mattered when we were deciding constitutional law. So with that, a couple of very interesting developments. And again, I smell fear in the air for the state. The fact that Justice Barrett asked for briefings by the state and they put up such a 55-gallon garbage pail of just bullshit tells me that they are scared. They don't have an argument. They're trying to throw every piece of junk they can at the court, hoping they find something that gets them a majority. They're trying to pick off Kavanaugh and maybe the chief based on what that concurring opinion that Kavanaugh wrote is. But if you go back to what Kavanaugh wrote in Heller 2, saying semi-automatics can't be banned, semi-automatic rifles, I think they have a tough road to hoe. So with that, guys, things are moving. Not always as fast as we want, but they're moving. And it's definitely going to be a three fingers kind of night as we dive through some more of this stuff and take a look at more of the nuances of this. But frivolous Frankie Friedman, I think your days for controlling 2A litigation in the Seventh Circuit are rapidly coming to a close. And even if we lose this appeal, we're on our way up to the Supreme Court. But don't forget, Bianchi's hanging out there. The Maryland semi-auto ban has been argued and is pending a decision in the Fourth Circuit Court of Appeals. And those oral arguments did not bode well for the state. So all kinds of things hanging out there. Guys, please like, subscribe, tell your friends, copy, paste, share these links around because you're going to get the most detailed, up-to-date, and nuanced information about the Illinois cases right here at Freedom of Steel. And as always, frag out.